I found the letter tucked inside a dusty file box in my garage on a humid Saturday morning in August, and it changed everything I thought I knew about my property in Cedar Hills, Georgia. The envelope was yellowed with age, addressed to the previous owner, and inside was a contract dated 2009 that made my heart race faster with each word I read. My name is Xander, and I had been living in my modest 3-bedroom ranch house for 2 years without any major issues beyond the usual suburban annoyances. The house sat on a corner lot with a decent backyard, nothing fancy, but it was mine. Or at least, I thought all of it was mine until that Saturday when I discovered that a 10-foot wide strip of land running along the back edge of my property had been designated as a utility easement for the Cedar Hills Homeowners Association back in 2009. The contract was crystal clear. The HOA had negotiated with the previous owner, a man named Robert Chen, to run underground utility lines for a new community irrigation system through properties on the eastern edge of the neighborhood. In exchange, they agreed to pay each affected homeowner $500 per month for the use of the land. The contract was set for 15 years with automatic renewal unless either party gave 90 days' notice. I read the document 3 times, my hands shaking slightly. $500 a month for 14 years. I grabbed my phone and opened the calculator app, my thumb fumbling over the numbers. That was $6,000 per year. Multiply that by 14 years, $84,000. The HOA owed me $84,000 in back rent. I sat down hard on an old lawn chair, dust puffing up around me. I'd never received a single payment, not one check, not one notification. When I bought the house in 2024, the title company had mentioned the easement in passing during the closing, but there had been no mention of any rental agreement. I assumed it was just a standard utility easement like you see on every property survey, the kind that gives the city or power company access if needed. But this was different. This was a private agreement between the HOA and the property owner, and I was now that property owner, which meant the contract had transferred to me along with the deed. I spent the rest of Saturday and most of Sunday researching property law in Georgia, easement rights, and contract transfers. My laptop history became a maze of legal websites, forum posts, and statute references. By Sunday evening, I was reasonably confident that I had a legitimate claim. When property transfers, so do the contractual obligations attached to it, unless specifically excluded in the sale. My purchase agreement had made no such exclusion. Monday morning, I called the Cedar Hills HOA office. A cheerful voice answered on the 3rd ring. Cedar Hills HOA, this is Patricia speaking. How may I help you? Hi, Patricia. My name is Xander. I live at 847 Oakmont Drive, and I need to speak with someone about a utility easement on my property. Oh, let me transfer you to our property manager, Mrs. Sharon Whitmore. One moment, please. The hold music was an instrumental version of a song I could not quite place. After about 2 minutes, a crisp voice came on the line. This is Sharon Whitmore. What can I do for you, Mr. Xander? Sharon Whitmore. I had seen her around the neighborhood, a woman in her early 50s with perfectly styled blonde hair and an expression that always seemed to suggest she was smelling something unpleasant. She drove a white Lexus SUV with a license plate frame that read, "I speak to managers." Mrs. Whitmore, I recently discovered a contract from 2009 between the HOA and the previous owner of my property regarding a utility easement. According to the contract, the HOA agreed to pay $500 per month for the use of the land. There was a pause. I am not aware of any such agreement. I have the contract right here. It is signed by the HOA president at the time, a Mr. Douglas Fletcher, and the property owner, Robert Chen. It is a legally binding document that should have transferred to me when I purchased the property. Another pause, longer this time. Mr. Xander, I have been the property manager here for 8 years, and I have never heard of any rental payments for easements. Are you certain this document is legitimate? Completely certain. I would like to schedule a meeting to discuss the 14 years of back payments that are owed. Her tone shifted, becoming colder. Mr. Xander, I think you may be confused about how easements work. The HOA has the legal right to maintain utility infrastructure on designated easement areas. That is standard practice. With respect, Mrs. Whitmore, this is not a standard easement. This is a rental agreement. The HOA is leasing the land from the property owner, and according to my calculations, I am owed $84,000 in back rent. I heard her breath catch. $84,000? That is absolutely ridiculous. I'm going to need to see this supposed contract. I can email you a scanned copy right now, or I can bring the original to your office. Email it to me. The address is on our website. Her voice had taken on a sharp edge. But I can tell you right now, Mr. Xander, the HOA is not in the business of making payments to homeowners for easements. If this contract even exists, it was likely terminated years ago. The contract specifies a 15-year term with automatic renewal. It does not expire until 2024, and I see no evidence that either party provided notice of termination. We will see about that. She hung up without saying goodbye. I immediately scanned the contract and emailed it to the HOA office, making sure to BCC my personal email account for my records. Then I made copies, lots of copies. I put the original in a fireproof safe I kept in my bedroom closet. I was not taking any chances. 2 days passed with no response. On Wednesday evening, I was grilling chicken in my backyard when I heard the doorbell ring. I wiped my hands on a towel and walked around to the front of the house. Sharon Whitmore stood on my porch, along with a man in his 60s wearing khaki pants and a polo shirt with the Cedar Hills logo embroidered on it. His name tag identified him as Bernard Cross, HOA board president. "Mr. Xander," Sharon said, her smile tight and artificial. "This is Mr. Cross, our board president. We would like to discuss this contract situation with you." I gestured for them to come inside, leading them to my living room. They sat on the couch while I took the armchair across from them. Sharon pulled out a tablet and stylus. "Mr. Xander," Bernard began, his voice attempting warmth but landing somewhere around patronizing. "We have reviewed the document you sent us. While it does appear to be an authentic contract from 2009, I think there has been a significant misunderstanding about its current validity." "I am listening," Sharon jumped in. "The contract was with Mr. Chen, not with you. When he sold the property, the contract became void." "That is not how property contracts work," I said calmly. "Unless the contract specifically states it is non-transferable, it transfers with the property. I have consulted with a real estate attorney who confirmed this." That was a small lie. I had not actually hired an attorney yet, but I had read enough to be confident in my position, and I wanted them to know I was serious. Bernard's expression hardened slightly. "Mr. Xander, I am going to be direct with you. The Cedar Hills HOA operates on a fixed budget. We cannot simply produce $84,000 because someone found an old contract in their garage. If we paid every homeowner who made a claim like this, we would be bankrupt." "Are there other homeowners with similar contracts?" Sharon and Bernard exchanged a glance. "That is not relevant," Sharon said. "It seems very relevant to me. How many properties have easements for this irrigation system?" 6 properties, Bernard admitted, "but you are the first to make any kind of claim about rental payments. The other homeowners understand that these easements are part of being in a community." "Have the other homeowners seen their contracts? Do they know they are supposed to be receiving payments?" Sharon set her tablet down with more force than necessary. "Mr. Xander, what exactly are you hoping to accomplish here? Do you really think you are going to get $84,000 out of this HOA? I think I am owed $84,000 according to a legally binding contract, and yes, I intend to collect it." Bernard leaned forward. "Let me make you a counteroffer. We will pay you $5,000 as a settlement, and we will consider the matter closed. That is more than generous. $5,000 for $84,000 owed? That is not even 6% of what I am owed." "Take it or leave it," Sharon said, "because if you push this, we will take it to our legal team, and they will tie you up in court for years. Do you have the money to fight a prolonged legal battle, Mr. Xander? HOA legal fees come out of a separate fund specifically for dealing with troublemakers." She emphasized the word troublemakers like it was a curse. "I am not a troublemaker for expecting a contract to be honored, and I'm not accepting $5,000. Bernard stood up. "Then I guess we will see you in court. And Mr. Xander, I should mention that the HOA has certain enforcement powers when it comes to property violations. I would make sure your property is in perfect compliance with all community standards. We would hate to have to issue any fines. It was a clear threat. Here, I stood as well, keeping my voice level. Are you threatening to harass me with false violations because I am asking for money I am legally owed? Not at all, Sharon said sweetly. We are just reminding you that all homeowners need to follow the rules. Have a good evening, Mr. Xander. They left, and I stood in my living room feeling my anger build. They were going to play dirty. Fine. Two could play that game. The next morning, I took a personal day from my job at the software company where I worked as a project manager and drove to downtown Atlanta to meet with a real estate attorney named Mitchell Grayson. His office was in a high-rise building with a view of the city skyline, and his rates were steep, but I needed professional help. Mitchell was a thin man in his 40s with wire-rimmed glasses and a meticulous way of reviewing documents. He read through the contract twice, then pulled up Georgia property law on his computer. This is actually pretty straightforward, he said after about 30 minutes. The contract is valid, it transferred with the property, and the HOA has been in breach for 14 years. You are absolutely entitled to the back payments. They offered me $5,000 as a settlement. Mitchell snorted. Of course they did. That's insulting. Here is what we are going to do. I'm going to draft a formal demand letter citing the relevant statutes and giving them 30 days to pay the full amount owed plus interest. Georgia law allows for interest on unpaid debts. At the legal rate of 7% per annum, you are owed an additional amount beyond the base $84,000. He tapped on his calculator. Roughly $37,000 in compound interest, so the total claim is approximately $121,000. My eyes widened. $121,000. That was life-changing money. That could pay off my car, wipe out my credit card debt, and still leave enough for a solid emergency fund. What if they refuse to pay? I asked. Then we file a lawsuit for breach of contract. Given the clear documentation, I would say you have better than a 90% chance of winning. The only question is how long the HOA wants to drag it out. But here's the thing about HOAs. They are managed by boards who are accountable to the homeowners. If we make this public, if the other residents find out the board has been breaching contracts and potentially costing the HOA hundreds of thousands of dollars in legal fees to avoid paying a legitimate debt, there will be pressure on them to settle. You said hundreds of thousands. What about the other 5 properties with easements? Mitchell nodded. Exactly. If they also have similar contracts and they find out about this, they will want their back payments too. The HOA could be looking at a liability of over $500,000 when you factor in all 6 properties plus interest plus legal fees. That is the kind of thing that could force a special assessment on all homeowners or even bankrupt the HOA. I left Mitchell's office with a retainer agreement signed and a plan in motion. He would draft the demand letter and send it via certified mail to the HOA board and their registered agent. We would give them 30 days to respond. When I got home that afternoon, there was a notice taped to my front door. It was from the HOA, citing me for excessive lawn height and unapproved exterior paint color on mailbox post. The fine was $250 for each violation, payable within 14 days. I stared at the notice in disbelief. My lawn was perfectly fine. I had mowed it 5 days ago, and my mailbox post was the same dark green it had been when I bought the house 2 years ago. This was retaliation, pure and simple. I took photos of my lawn and mailbox, then measured the grass height with a ruler. According to the HOA bylaws, grass could not exceed 4 inches. Mine was 2.5 inches. The mailbox post was listed in the architectural guidelines as an approved color. I scanned everything and sent it to Mitchell along with a description of what was happening. He replied within an hour. Document everything. This is evidence of retaliation and harassment. It actually strengthens your case. Over the next 2 weeks, I received 4 more violation notices. One claimed my garbage cans were visible from the street before 6 p.m. on trash day, even though trash pickup was at 7 a.m. and I had put the cans out at 6:30 a.m. Another cited me for parking my car on the street overnight, even though there was no such rule in the bylaws. They were making things up. Each time, I documented everything with photos, timestamps, and references to the actual bylaws showing I was in compliance. Mitchell assured me this was all building a case for harassment. On a Thursday evening, 3 weeks after my meeting with Sharon and Bernard, I was coming home from work when I noticed a woman walking slowly past my property, taking photos with her phone. She was in her late 40s with short brown hair and the determined expression of someone on a mission. "Can I help you?" I called out. She jumped slightly, then recovered. "Oh, I'm just documenting violations for the HOA. I am Jennifer Morrison, the new compliance officer." "Compliance officer? The HOA has never had a compliance officer." "Well, we do now. The board appointed me last week." She smiled, but it did not reach her eyes. "I'm noticing several issues with your property. The edging along your driveway is not clean, your house numbers are faded, and it appears you have an unapproved garden decoration." She pointed at a small ceramic gnome I had placed near my front steps. It was maybe 8 inches tall. "You're citing me for a garden gnome. Yard decorations require architectural committee approval. Did you submit a request?" "For an 8-inch gnome? No one submits requests for things like that." "They should," Jennifer said primly. "The rules exist for a reason. I will be issuing you a notice. Have a good evening." She walked away, still taking photos. I went inside and immediately called Mitchell. "They have created a position specifically to harass you," he said. "This Jennifer Morrison, does she live in the neighborhood?" "I think so. The name sounds familiar." "I will have my paralegal do some research. In the meantime, keep documenting. This is actually helpful for us. The more outrageous they get, the easier it is to prove retaliation." Mitchell's demand letter arrived at the HOA office via certified mail the following Monday. It was a comprehensive 8-page document laying out the legal basis for my claim, calculating the exact amount owed including interest, and demanding payment within 30 days. It also included a section noting the pattern of retaliatory violations and harassment I had experienced since making the HOA aware of the contract. I knew they had received it because Jennifer Morrison was at my property within hours, taking photos of every inch of my yard and house exterior. Over the next 3 days, I received 11 violation notices. 11. For things like inconsistent mulch depth in landscaping beds, visible rust on outdoor spigot, and my personal favorite, negative aesthetic impact of vehicle color on neighborhood appearance. That last one was about my truck, a perfectly normal blue Ford F-150. But then something unexpected happened. On Wednesday afternoon, a man I recognized from a few streets over knocked on my door. His name was Paul Donovan, and he lived on Maple Drive. "Kevin, right? I am Paul. Listen, I heard through the grapevine that you have been having some issues with the HOA about an easement on your property." Word travels fast. "Small neighborhood. My property has an easement for the same irrigation system. I just went through my paperwork from when I bought my house and I found a contract just like yours. $500 a month. I bought my place in 2015 and I have never received a payment either." My heart raced. "Have you contacted the HOA about it?" "I wanted to talk to you first. If we both have claims, maybe we should coordinate. I know there are at least 3 other houses on Maple and Oak that have the same easements. We should definitely talk. Do you want to come in?" Paul and I spent 2 hours going through our documents and comparing notes. His contract was identical to mine except for the dates and property description. He was owed 9 years of back payments, $54,000 plus interest. "The HOA is going to lose their minds," Paul said. "If all 6 properties make claims, we are talking about potentially over $500,000. I have already filed a demand through my attorney. They have been retaliating against me with bogus violation notices." Paul's expression darkened. "I got 3 violation notices this week. I thought it was just Sharon being Sharon, but maybe it is connected." "When did you start looking into your contract?" "About 10 days ago, right after I heard about your situation." "So they knew you were looking into it and they started hitting you with violations. That is the same pattern." We decided to organize a meeting with the other 4 property owners who had easements. Paul knew who they were and agreed to reach out. We set up a meeting for that Saturday at my house. Saturday arrived, and with it came a gathering that felt like a small revolution. 6 homeowners total, all with the same easements, all with the same contracts, All owed years of back payments. Besides Paul and me, there was Linda Hoffman, who had owned her property since 2011, Marcus Webb, who bought in 2013, and two others, Rachel Torres and David Kim, who had purchased in 2019 and 2020, respectively. We sat around my dining room table with copies of all our contracts spread out. Mitchell had agreed to join us by video call to answer legal questions. Collectively, Mitchell said from my laptop screen, you are looking at approximately $540,000 in back payments plus interest. The total liability for the HOA is well over $700,000. Linda, a woman in her 60s with gray hair and a no-nonsense attitude, whistled. That is going to bankrupt them. Possibly, Mitchell agreed, but that's not your problem. They entered into contracts they did not honor. The law is clear on this. Marcus, a black man in his 30s who worked as an engineer, leaned forward. What are our options? Can we file a class action or something? You could, but I would actually recommend individual lawsuits. Class actions take longer and result in smaller individual payouts after legal fees. If you each file separately but coordinate your legal strategy, you can put maximum pressure on the HOA while maintaining individual control over your cases. Would you represent all of us? Rachel asked. She was a young woman, probably late 20s, with long dark hair. I can, or I can refer you to colleagues. But yes, I am willing to take on all 6 cases if you want coordinated representation. We discussed it among ourselves after Mitchell signed off. The consensus was clear. We all wanted to pursue our claims, and we wanted Mitchell to represent all of us for consistency. We would each pay our own retainer and legal fees, but we would share information and strategy. Over the next week, 5 more demand letters went out to the HOA. The neighborhood rumor mill went into overdrive. People started talking. There were arguments at the community pool, heated discussions at the mailbox clusters. Some homeowners supported us, saying the HOA needed to honor its contracts. Others were furious, worried about special assessments to cover the liability. Sharon Whitmore was reportedly losing her mind. According to someone who attended the emergency board meeting, she spent 20 minutes screaming about money-grubbing homeowners and frivolous lawsuits. Then the HOA did something truly stupid. They hired a law firm known for aggressive litigation tactics and sent cease and desist letters to all 6 of us, claiming our demand letters constituted harassment and threatening to sue us for defamation and intentional infliction of emotional distress. Mitchell laughed when he saw the letter. Actually laughed. This is a slap suit threat, he explained. A strategic lawsuit against public participation. It is meant to intimidate you into dropping your legitimate claims. Georgia has anti-slap laws. If they actually file these ridiculous suits, we can get them dismissed quickly and potentially recover attorney fees. This is the dumbest thing they could have done. He drafted responses to the cease and desist letters that were polite but firm, explaining that we were exercising our legal rights to pursue breach of contract claims and that any attempt to silence us through meritless litigation would be met with sanctions motions. The HOA backed down from the lawsuit threat, but they did not back down from the harassment. All 6 of us were being bombarded with violation notices. Jennifer Morrison, the compliance officer, was spending hours each day walking through our properties looking for anything she could cite. It got so absurd that she cited David Kim for improper holiday decoration timing because he still had a small American flag on his porch from Memorial Day, and it was now mid-June. When David pointed out that displaying the American flag was protected and not subject to HOA timing restrictions, Jennifer wrote him up for argumentative behavior toward HOA official. That was when I decided we needed to go public. I had been documenting everything, and I had a file several inches thick of bogus violation notices, photos proving compliance, and evidence of the harassment pattern. I contacted a local news reporter named Andrea Chen, who had done stories on HOA overreach in the past. She was interested immediately. "This is exactly the kind of story viewers care about," she said when we met at a coffee shop in downtown Cedar Hills. HOAs abusing their power, retaliation, contracts not being honored. When can we film? Anytime. I can also connect you with the other 5 homeowners if they are willing to talk. 4 of them agreed to interviews. Marcus preferred to stay out of the spotlight, but he gave Andrea copies of his documentation. The story aired on a Thursday evening in late June during the 6 o'clock news. It was a 7-minute segment that laid out the entire situation: the contracts, the money owed, the retaliation, the harassment. Andrea had done her homework, interviewing legal experts who confirmed our claims were legitimate, and HOA governance experts who called the board's behavior appalling and potentially criminal. The story went viral locally. By Friday morning, it had been picked up by news outlets in Atlanta and several national HOA watchdog websites. My phone would not stop ringing with interview requests, but more importantly, the other homeowners in Cedar Hills started paying attention. A petition began circulating to recall the entire HOA board. Within a week, it had over 200 signatures, well more than the threshold needed to force a recall vote. Sharon Whitmore tried to dismiss the petition on procedural grounds, but the HOA bylaws were clear. The recall vote had to happen within 45 days. During this time, Mitchell filed lawsuits on behalf of all 6 of us in Gwinnett County Superior Court. The complaints were public record, and Andrea Chen did a follow-up story. The HOA hired a second law firm, this one more reputable, to handle the litigation. Their strategy became clear in the answer and counterclaims they filed. They argued that the contracts had been entered into by a previous board without proper authorization, that they were unconscionable and therefore void, and that even if they were valid, the statute of limitations barred claims for payments more than 4 years old. Mitchell tore those arguments apart in his reply. The contracts had been properly authorized, there was nothing unconscionable about a standard rental agreement, and the statute of limitations did not start running until we knew or should have known about the breach, which was when we discovered the contracts. The case was assigned to Judge Walter Harrison, a respected jurist who had been on the bench for 15 years. He scheduled a hearing on the HOA's motion to dismiss for late August. Meanwhile, the recall vote was scheduled for mid-July. The entire neighborhood was divided. Signs appeared in yards either supporting or opposing the recall. There were 3 separate Facebook groups arguing about the situation. It was chaos. The day before the recall vote, I received a visit from Bernard Cross. He came alone this time, looking exhausted. "Kevin, can we talk?" I let him in, though I was wary. We sat in the living room. "I am not here in any official capacity," Bernard said. "I am here as someone who has lived in this neighborhood for 20 years and cares about this community." "Okay. This whole situation has gotten out of hand. The legal fees are already over $200,000. If we lose in court, we are looking at paying out over $700,000 total. That is going to require a special assessment of almost $3,000 per household. People cannot afford that. This is going to destroy the neighborhood. Bernard, I did not create this situation. The HOA entered into contracts and then failed to honor them for over a decade. That is not my fault." "I know. I have been looking into how this happened. The contracts were signed by a board that was in place before I joined. They apparently set up automatic payments but used the wrong account, some kind of escrow account that got closed in 2011. The payments stopped, and no one noticed because there was poor record keeping. Then, when new board members came in, they did not even know the contracts existed. That is incompetence, not a defense." "I know," he said again. "I am not trying to make excuses. I'm trying to find a solution. What if we can get the votes to approve a settlement, something reasonable that gets you paid but does not bankrupt everyone?" "I am listening." "We pay you and the others 50% of what you are owed, payable over 3 years. We formally terminate the easement contracts going forward, and we drop all the violation notices, and any retaliation stops immediately." 50%? That is still trying to shortchange us? "It is what we can realistically pay without destroying this community. Please, Kevin, think about your neighbors who had nothing to do with this." I thought about it. I genuinely did. But then I thought about the harassment, the bogus violations, the cease and desist letters, Jennifer Morrison with her camera and clipboard, Sharon Whitmore calling us money grubbing and threatening us with legal warfare. "No," I said. "The HOA made this adversarial. You treated us like criminals for asking for what we were owed. You could have handled this professionally from the beginning, but instead you chose intimidation and retaliation. I am not settling for 50%. Bernard's shoulders slumped. Then I guess we will see how the vote goes tomorrow. The recall vote was held at the community center on a humid Wednesday evening. The room was packed with angry homeowners. Sharon Whitmore sat at the front table with the other board members, her face a mask of fury. Bernard looked resigned. The vote was not even close. The entire board was recalled by a margin of 73%. Immediately after the results were announced, a new interim board was elected from volunteers in the audience. The new president was Linda Hoffman, one of the 6 homeowners with easement claims. Sharon Whitmore stood up, her face red. "This is a sham. You people are making a terrible mistake. When your property values tank and you cannot afford the assessments, do not come crying to me." "You are no longer the property manager, Mrs. Whitmore," Linda said calmly. "Please vacate the premises." Sharon grabbed her belongings and stormed out, Jennifer Morrison hurrying after her. The room erupted in applause. Linda gavelled the meeting back to order. "First order of business, the new board directs our legal counsel to negotiate a reasonable settlement with the 6 homeowners who have filed suit. Second order of business, all violation notices issued in the past 60 days are under review for validity. Third order of business, the position of compliance officer is eliminated effective immediately." More applause. I felt a weight lift from my shoulders. Over the next 2 weeks, the new board's attorney reached out to Mitchell. They had reviewed the contracts and the legal analysis. They acknowledged the claims were valid. They wanted to settle. The negotiations took place over several conference calls. The HOA's position was that they could pay 75% of the total amount owed, including interest, with the first 50% paid within 60 days and the remainder paid over the following 2 years. They would formally acknowledge the contracts had been valid, provide written apologies for the harassment, and ensure all violation notices were withdrawn with expungement from our records. Mitchell advised that this was a reasonable offer. "You could hold out for the full amount, but litigation is expensive and time-consuming. Even if we win, which I believe we would, collecting the full judgment might be difficult if the HOA has to declare bankruptcy. 75% with guaranteed payments is a solid outcome." All 6 of us discussed it together. We had been through the ringer, and the idea of prolonged litigation was exhausting. We agreed to accept the settlement. The settlement agreement was signed in mid-September. I received my first payment in October, $60,000. It was surreal seeing that direct deposit in my bank account. The remaining $21,000 would come in installments over the next 2 years, but the bulk of it was mine now. I paid off my car. I eliminated my credit card debt. I put $30,000 into savings. For the first time in my adult life, I felt financially secure. But the story was not quite over. In late October, I received a call from a detective with the Gwinnett County Police Department. "Mr. Xander, this is Detective Lisa Ramirez. I am calling about Sharon Whitmore and Jennifer Morrison. We have received reports that they may have engaged in fraud and embezzlement during their time managing the Cedar Hills HOA. I understand you had some interactions with them?" My stomach dropped. "What kind of fraud?" "The new HOA board brought in a forensic accountant to review the books. They found evidence that Mrs. Whitmore and Mrs. Morrison were creating false vendor invoices and paying themselves through shell companies. We are talking about over $150,000 embezzled over the past 5 years. "That is insane. We are building a case. I was hoping you might be willing to provide a statement about the retaliation and harassment you experienced. It helps establish motive and consciousness of guilt. They were trying to discredit and intimidate you and the others because you were asking questions that might have led to discovery of the embezzlement." I met with Detective Ramirez the next day and provided a detailed statement along with all my documentation. Mitchell provided copies of the legal filings. The other 5 homeowners also gave statements. In January 2027, Sharon Whitmore and Jennifer Morrison were arrested and charged with theft by taking, fraud, and racketeering. The prosecution alleged they had set up a sophisticated embezzlement scheme using fake landscaping companies, maintenance contractors, and consulting firms. They had been siphoning money from the HOA for years. The case went to trial in June 2027. I was called as a witness to testify about the harassment and retaliation campaign. Sitting in that witness box, looking at Sharon and Jennifer at the defense table, I felt a strange sense of vindication. "Mr. Xander," the prosecutor asked, "can you describe how Mrs. Whitmore and Mrs. Morrison treated you after you made your claim about the easement contract?" "They tried to bury me in violation notices," I said. "They created a position specifically to harass me and the other homeowners who had claims. They threatened us with legal action. They treated us like criminals for asking for money we were legitimately owed. Looking back, I think they were terrified that our claims would lead to a deeper investigation of the HOA's finances, which is exactly what happened. The jury deliberated for 2 days. They found both women guilty on all counts. Sharon Whitmore was sentenced to 7 years in prison and ordered to pay full restitution. Jennifer Morrison, who had cooperated with prosecutors and testified against Sharon, received 3 years probation and a restitution order. The neighborhood slowly returned to normal. Linda Hoffman and the new board did an excellent job managing the HOA. They instituted transparent accounting practices and regular financial audits. The special assessment to cover the settlement payments and legal fees was smaller than feared, around $1,800 per household, paid over 2 years. Most people accepted it as the cost of cleaning up the previous board's mess. I received my final settlement payment in October 2028, exactly 2 years after the first payment. My total recovery was $91,000, 75% of what I was owed. Not bad for finding a document in a dusty file box. Paul Donovan became a good friend. We still grab beers occasionally and talk about the craziness of that year. Linda Hoffman served 2 terms as HOA president before retiring. Marcus Webb took over after her and has been doing a great job. Sharon Whitmore's appeal was denied. She is currently serving her sentence at a state facility. Jennifer Morrison completed her probation and moved out of state. I heard she was working at a grocery store somewhere in Tennessee. As for me, I am still in my house on Oakmont Drive. The lawn is always properly maintained, though not because I fear HOA violations. I just like keeping things nice. The ceramic gnome is still by my front steps. No one has bothered me about it. Sometimes I drive past the area where the irrigation system runs underground through my property, that 10-foot strip of easement that started everything. The grass grows over it like it is just ordinary land, which I suppose it is. But to me, it will always be the place where I learned that sometimes standing up for yourself, even when it seems like the world is against you, is exactly the right thing to do. The file box where I found the contract is still in my garage. I keep it as a reminder that the most ordinary moments can change your life. You never know when a dusty document or a forgotten agreement might turn into something significant. You just have to pay attention, do your research, and be willing to fight for what is right. And maybe, just maybe, keep copies of everything in a fireproof safe. The HOA owns no one anymore. The contracts were fulfilled and settled fairly. The criminals were punished. The neighborhood learned important lessons about accountability and oversight. And I learned that even against seemingly overwhelming opposition, with the right combination of evidence, persistence, and help from good people, justice can prevail. Every time I look at my savings account balance, still comfortably padded from those settlement payments, I smile. Not because of the money itself, though that certainly helped, but because it represents something bigger. The idea that ordinary people can stand up to institutions that abuse their power, that contracts matter, that the law applies to everyone, even homeowners associations. Cedar Hills is a better community now. People are more engaged. Board meetings have actual attendance. Financial statements are scrutinized. No one wants a repeat of the Sharon Whitmore era. Last month, at a neighborhood barbecue, someone asked me if I regretted stirring up all that trouble over the easement contract. I thought about it for a moment, then shook my head. "Not for a second," I said. "Sometimes trouble is exactly what a situation needs. The HOA was broken, corrupt, and abusive. If my claim had not exposed all of that, who knows how much longer it would have gone on." The person nodded thoughtfully, then changed the subject to something about the upcoming community yard sale. Normal neighborhood conversation. That is how I knew we had finally moved past it all. But I will never forget that Saturday morning when I found that yellowed envelope, read that contract, and realized my life was about to get very complicated. Some people would have ignored it, decided the hassle was not worth it. I am glad I'm not one of those people. I'm Kevin Xander. I live at 847 Oakmont Drive in Cedar Hills, Georgia, and I discovered the HOA owed me 14 years of back rent for a utility easement on my property. And I collected every penny I could, exposed corruption, and helped reform a broken system in the process. Not bad for a guy who just wanted to grill chicken in his backyard and live a quiet life.